submitted our petition and our medical evidence to the court, and that opens up our case. Okay, so now the court gives us back something called our docket number. So that opens up a case in our court, and our courts, our probate courts, are what govern our guardianship system here, and they are done by county. So depending on where you live, you're going to either, in this area, you're going to either be in Worcester County or Middlesex County, for the most part, depending on what town you're in. Middlesex County is much busier, and I think a little bit more challenging to deal with than Worcester. But either way, you know, that's what you're working from. Once the paperwork gets processed, the next thing that happens is you get a letter back from the court, which is called a citation, and that's an order of notice. So that piece of paper tells you that you have a certain period of time to give notice. You as the petitioner must give notice to all the interested parties in your case, and it tells you how to give that notice. This is the area that is the most confusing to people because it cites a statute which is supposed to tell you who the interested parties in your case are. And it is, you know, not the norm for an average person to go looking up a statute, and when you look at the statute, it's still kind of confusing to figure out who an interested party is in a case. So I'm going to tell you who your interested parties are on average for almost every family, okay? And your interested parties are pretty much everybody who lives in your household, all right? Even if you have a live-in grandma or grandpa, nanny, or anybody else who just stays with you. So anybody that lives in your house, even if they're not related to you, has to get notice because they share your home, okay? Anybody who is a sibling to your child, even a minor. Sometimes people get confused about that. Why would my 7-year-old need to get notice? They still do. They still need to get notice. Your individual who you are pursuing guardianship for also needs to get notice. And they need to get notice in a special way, and we'll talk about that in a minute. If you have any caregivers that are full-time caregivers, they need to get notice. So, and when I say caregivers, I mean like a live-in caregiver too. So that goes to somebody who lives with you as well, okay? And then there are other people. So if you have somebody who is a healthcare proxy, healthcare agent, if you have somebody who's a representative payee and it's not you, and there's a couple of other lists of people that need to get notice. An ex-spouse, parent, needs to get notice. So even if they have no contact, they need to get notice. Biological parent needs to get notice. Okay? And there are going to be special circumstances. So if you have that situation, you do need an attorney. This is one of those times you should not do this alone. You should absolutely at least have a consultation with somebody to figure out how to maneuver the system. Okay? You may not need full representation, but you should absolutely speak with somebody to make sure that you are protecting yourself and getting, you know, the best advice that you need here. In your order of notice, it's going to give you information about what newspaper to publish in. If you know all of the parties to your case, you do not need to publish in the newspaper. Do not waste your money and do not make your case public. You do not need to do that. People do not know that. People do not understand that. Please do not publish in the newspaper if you do not have to. Okay? You don't need to make it an announcement to the world. So I know a lot of people do that and they don't understand that. but you don't need to do that. You only need to publish in the newspaper if you don't know all the parties to your case. If you can give notice to everybody in your case, then you are all set, okay? So you only have a very short window of time to give notice. If you have anybody who lives out of state, you have to give notice by certified mail. If you have anybody who lives out of the country, your notice period is much longer, and you probably need a consultation by an attorney because you're going to have to give special notice and you're going to have to prove that you gave notice in a special way as well. So that's another time when you'll need a consultation and help, okay? Everybody else can get notice in hand or by first-class mail. Email does not work. You have to give notice by mail or in hand. And then you fill out the form that they give you, and you swear by signing it that you gave notice to these people in this way at this address, okay? The person who the guardianship is about must get notice in hand by a disinterested third party. That disinterested third party can be somebody at the school, but you have to make sure that they do it right and that they meet the time frame. So it's 2 weeks before the return date that's listed on the bottom of the citation. If your return date is the 30th, then you must give notice 2 weeks before the 30th. And that's the day before the 2 weeks. So is your last date. You usually get the notice a few days into the 30-day notice period. So you usually have about 10 days to get all of this stuff done. Okay? So you got to work quickly. If you're somebody who doesn't always open your mail right away, you really want to be thoughtful about that. Sometimes when you can go into court, like in Worcester, they'll very often, when you file, give you your citation that same day. In Middlesex, not usually. So that's how the different counties can be very different. Middlesex, you'll have to wait for them to mail it to you, which takes a few extra days. And you have to be watching for that. So that's how our county system can differ from place to place. Sometimes in Middlesex, they'll give you the citation that day, but if they're busy, they won't process it right away. Okay? So notice is the area that most people have difficulty managing because the rules are for lawyers. It's a court case and the rules are for lawyers, not for average people. So again, you know, having a consultation can help. Here's another place where you can get help. Every court has a day where they have lawyers of the day. In Middlesex, it's on Thursdays. I don't know in Worcester what their day is, but they have somebody who volunteers, somebody like me, who volunteers for a good chunk of the day for guardianships, who will be there just to help answer questions. Now, you're supposed to meet the criteria for free legal services, and not everybody meets that criteria. But sometimes, if we're not busy, we'll help anyway. So it's worth going up and asking and signing up for the lawyer of the day. The people behind the counter can't give you legal advice. The people who work at the courthouse that are the clerks, they are not allowed to give you legal advice. They can give you the forms, but they're not allowed to answer your questions and tell you who am I supposed to give notice to. So don't get frustrated with them. They can't be your lawyers. In fact, a lot of them aren't lawyers that are behind the counter. So they can't, because imagine you can come back to them and say, oh, well, so-and-so told me I didn't have to give notice to blah, blah, blah. But maybe they didn't have all the information. And, you know, again, it's really not their job and they are not supposed to. They could get fired for doing that. So Your best bet is to try for the guardianship person on the guardianship day. And if you get somebody nice like me who doesn't have a long line that day, we'll probably stop and help you anyway, even if you don't meet our guidelines. Okay? Because we want to help you. We want you to be successful. We don't want you to not give proper notice and have to start your case again, get a new citation, pay another $15, and start again with the process. And this is where, if you know yourself and you think you're going to have trouble with something like this, putting it in the paper can overcome all of the notice issues. So if you would rather just do that, then you can go ahead and put it in the paper. You still have to give in-hand notice to the disabled person. You can't overcome that, but you can overcome the mailing to everybody else, etc. Okay? You give them that piece of paper, you make copies of that citation, and you make copies of the petition. So you have to keep a copy of that petition that you filled out. So and it says right on that piece of paper what you're giving notice to. So it tells you, you give a copy of this citation and a copy of the petition. You do not give them copies of the medical evidence. They're not entitled to that. Even the person that you're pursuing guardianship for is not entitled to that. Do not give them that. They can, if they do end up objecting, which we're going to talk about next, they can go to the court and get it themselves. But that medical evidence is private, so you don't send that around to people, okay? And that actually is a really good question. So I'm going to actually talk about one more thing. Let me check my timing here. How am I doing on time? Okay. So I'm running a little behind, but you're asking great questions and I don't want to stop the flow. So when you fill out your petition, it asks you what your reasoning is for the guardianship. You don't want to fill in all the medical criteria there. You just want to say, see my clinical team report, see my medical certificate. And the reason for that is your medical certificate and your clinical team report are impounded at the courthouse. That means only the parties to the case can see it. Your petition, however, is a public document. Not only are you sending that out to people that are interested parties, but anybody, any public person can go to the courthouse and can request that case file, and can look at that petition. They can't get the impounded evidence, but they can see a petition for guardianship, okay? So you never want to put sensitive information there. So it's important. Okay. So, moving on. You must also give DDS notice as well if they are potentially going to serve your person someday. So if you have somebody with an intellectual disability, if you are using a clinical team report, you always want to serve DDS as well. And you just send it to their main office in Boston, not your regional office. It just always goes into Boston, to the main office, to DDS Legal. They never answer, they never get involved, but you send it there so that you have given service to DDS. Okay. So now we have to talk about Roger's authority. If you have somebody who also needs antipsychotic medications, and there are some other kinds of things that come up, but we don't have time to go into a lot of detail today, so we're going to talk only about those antipsychotic medications, which comes up fairly often for people, then you need to do some extra work. And that extra work looks like this. It's a clinician's affidavit, so your treating psychiatrist or your treating clinician who provides those medications that are on that antipsychotic medication list, even if you're not using them for psychosis, whatever the reason that you're treating with antipsychotic medications, you still need to go to the court for extra authority. A guardian does not have the ability to sign off on a treatment plan that includes antipsychotic medications without getting additional authority from the court. And this requires an appointment of an attorney for your person. So this complicates your case. This is another area where you very much want to consider bringing your own attorney into the case, because now your child is going to have an attorney appointed for them. It's going to be somebody from a list from CPCS, and they very often, almost always, immediately object to the guardianship and to the treatment plan. They are told and trained to object in every case. They don't always object to every case, but they most of the time will object to every case. Not because they don't think that your child needs a guardian, not because they don't think that your child needs these medications, but because they are told to go through the process of getting an independent medical exam and of really pursuing the full hearing to make sure that this is not rubber stamped. So that is how they are trained, and that is generally what they do. And they fully admit this, and they talk about this, and they really believe that this is the best outcome for people who need these medications. Okay? So having said that, that doesn't mean, again, that you're going to come out with, you know, a bad outcome. It doesn't mean that your medication list is going to change. It doesn't mean that your provider is going to change. It doesn't mean that you're not going to get guardianship. But it is going to extend your process. It's likely to mean that there's going to be an independent medical examiner, and it's going to be a longer hearing. And again, it's probably in your best interest to have an attorney who can be by your side and help you through that process. The attorney appointed for your child is not your attorney. It is not their responsibility to explain things to you. They are, in fact, are opposing counsel. So this is an adversarial process, even if they're friendly, even if they're helpful. And as the years wear on, they will become more and more helpful and more collaborative with you once the initial process has been gone through and gone over. But in the beginning, it probably would be more suitable for you to make sure that you're getting the counsel that you need through your process. So just take that as, you know, some advisement. It's not that way for everybody. It's not that way for every guardianship. And we have had lots of guardianships that have gone through without a hitch. But we've had plenty that have been pretty involved as well. Okay? So when you are going through with Roger's authority and Roger's counsel is appointed, it takes a little while and extra hearings before we can get to our hearing day. And again, usually there's an objection, then there's a motion for an independent medical exam. So if there is no Roger's authority and no clinician's affidavit, and we have passed our day for objections to arise. So we've given everybody notice. They've had time to think about whether they want to object to this guardianship or anything about this guardianship process. And nobody has spoken up, and there are no objections on the record. Now we know that we have an uncontested case, and we can schedule our hearing. Sometimes we know we're not going to get an objection. We've got two parents in front of us. We've got the only other interested party is our person who we're going to pursue guardianship for, or we've got minor children. I mean, we just know we're not going to have an objection. And depending on the county that we're in, we don't always have to wait to schedule a hearing. So again, it really depends what county we're in. And we can schedule a hearing if we know we're going to be uncontested, because it can take 6 to 8 weeks, for example, in Middlesex, to get on a judge's calendar. And again, this is why you need to, get started in advance, 4 to 6 months out, so that you can go through this whole process. And this is really going to be different depending on where you are. Worcester is not as bad. So when you schedule your hearing, you have to then give notice for your hearing as well. Hearing notice is to all of the same people, but you don't have to do in-hand notice. And everybody can get notice just by regular first-class mail. So when you are going to court, you have to come to court with several things in hand. Parents no longer need to get Corey checked. But sometimes you show up and the clerks of court don't realize that. And they still give you the forms. So, that's one of the things about probate court that can be a little frustrating sometimes, is that, the procedures in the process are not uniform. So just be prepared to fill out a Corey form when you go, and they're going to ask you just for things that you already know, like your mom and dad's names and your social security number and your date of birth. And this is going to be for anybody that is going to be the proposed guardians. Okay, so if you are suggesting anybody besides yourselves, like another sibling, as a proposed guardian, you need to have that information ready for everybody that's a proposed guardian. You need to come with a proposed decree. So you do have to fill that out. Those forms, by the way, are all on the court's website. So all of those forms are available. If you don't know how to find them, those are the things that the clerk at the counter can help you with. They will give you the forms and help you fill them out. You also need the return of service. So that form that comes with your citation, you fill out that return of service, and you write in there that you gave the citation and also the notice of hearing, because you're sending out both the citation and a notice of hearing, right? Because you're giving notice of the hearing date as well. And then you write the names of the people that you gave notice to, and at the top, the person who gave the in-hand notice, who wasn't you, because it has to be that disinterested third party, to the person that you're pursuing guardianship of, they have to sign off on where they gave that in-hand notice. All right? So when you get that form, you'll see it and you'll know that how they have to fill that out. It's just a few places that they have to fill in the blanks. And that's it. And then there's a few more forms if you are pursuing Rogers Authority. Findings of fact, a treatment plan, and again, because it's more complicated, I do recommend that you really consider getting an attorney to help you. Now, after you have been appointed, and by the way, your hearing in front of the judge lasts, if you're lucky, 5 minutes. You'll be there for a while. You have to wait in line to file your forms again. It takes a while for the judge to take the bench, and you could be there 2 hours or so. They do try to take the guardianship cases first, especially if they're uncontested. You do not have to bring your child with you. I think a lot of people don't know this. Your child does not need to be there, probably should not be there. If your child wants to be there, it's their right and they can come, but it's a long, boring morning for no reason. The judge will talk to them because the judge will be polite and won't want them to have come for no reason, but there is no reason for them to be there. They have been served with their papers, and they are an opposing party. So they really don't need to come if they have no objection. And I would frankly leave them home. The last time I was in court, which was about a week and a half ago, we had a woman there who was very distraught and needed to be dragged out of there. I would not, that happens often. Like, I would not want my child there in the middle of all of that. It was really just, the judge had to leave the bench for her safety. You know, it's not a fun place to be a lot of times. So, yeah, so I would not necessarily bring my child there if you don't need to. So you get your decree and your letters, and now you're a guardian. So what happens next? Well, in 60 days, you have to file a Careplan report. This is super easy. It's going to ask you a lot of questions that you really already know and you know how to answer. And it's all about your person and what's happened in the last 60 days. And the reason that they ask these questions is because they want to make sure that you know what's going on. They're really not meant for parents. They are meant for non-family member guardians who, honest to God, sometimes never actually see the people. So they really want to make sure that somebody is reporting back to the court what is going on with this person. And then you're going to fill one of those out every year on the anniversary date of the guardianship. So at 60 days, just once, and then every year on the anniversary date. And then you're going to give it to your person who is under guardianship, either in hand or by certified mail. But the instructions on the form are really easy. It's very clear what you need to do. It's a no-brainer. And then you mail them into the court. And that's it. If you don't do it, you're going to get a scary letter from the court that tells you that you missed your date, and you don't want to get those letters. So you need to get them out. There's nothing from the court reminding you to do it. So you have to calendar this so you remember, okay? They don't have a tickler system. You need to do that for yourself. And that is the guardianship process.